Alessandra Gonzalez, and as one of the partners, founding partners of LEC, it's a pleasure to have here two American colleagues who will talk to us about FATCA. One is Littman, he's partners of Baker Hostetler, and his practice is focused on international tax planning, tax controversy matters, and he has also served for 5 years for Legislation Counsel to the Joint Committee on Taxation of the United States Congress, especially while FATCA was being written. And also Jay Nanavati, who is also a lawyer of Baker Hostetler, and whose practice is focused on criminal tax defense, and he's former Department of Justice Assistant Chief for the Western Criminal Enforcement Section of the Tax Division. This conversation we are going to have now with them is very interesting because they will give us an idea of how FATCA works and how it will imply Brazilian companies. We can start with Jay. Give us a briefing of the emblematic case of the UBS, who led then U.S. government to think about a law to enforce, to prevent this kind of crime, tax crime, as FATCA.
Well, thank you very much for having me. Yes, it's correct that when I was at the Department of Justice of the United States, the UBS case, as we have come to call it, began. And it began when only one person was prosecuted for tax evasion and for using an offshore bank account. And that one person cooperated with the authorities and told the authorities about how he worked with UBS to hide his money in Switzerland. This case, which had a lot of very interesting details, diamonds being moved in toothpaste tubes from the US to Switzerland, things like that, made American authorities, especially lawmakers, legislators, very angry. And they wanted to come up with a solution that would stop this from ever happening again. And that is part of the reason, at least, that FATCA came into being in 2010.
Ellen, can you give us a briefing of what is FATCA, what shall Brazilian companies worry about?
Sure. Let me describe very briefly how FATCA works. The main goal of FATCA, which stands for Financial Account Tax Compliance Act, is to induce foreign financial institutions, that is non-U.S. financial institutions that directly or indirectly receive U.S. source income, which is pretty much many or most or even perhaps all foreign financial institutions in some way, to report on their U.S. account holders. FATCA requires the U.S. withholding agents and participating foreign financial institutions, and those are foreign financial institutions that enter into an agreement with the IRS to be compliant under FATCA. Those entities must withhold 30% from payments made of U.S. source income to non-participating FFIs. That is an inducement to non-participating FFIs to participate. There's an alternative, an intergovernmental agreement alternative to the legal rules of FATCA under the statute and the regulation, and that is, the current state of that is there are 3 joint statements, which are statements in principle between countries and the United States, and those countries are the 5 largest EU countries, which have one joint statement, and Japan and Switzerland, which have their own separate joint statements. And the 5 EU countries have entered into a model agreement, which means that they haven't signed it yet, but they've made it public as to what they're going to agree on to either, and other countries may sign up to a similar agreement. It is a model agreement, as I said. The agreements come in 2 versions. They come in a reciprocal version, which means that the countries, and this is a bilateral agreement, the countries would exchange information, or non-reciprocal, which means that the FATCA partner country would provide the information to the IRS. And the way those agreements work, the local government, in this case, where the government would be the government of Brazil, would collect that information from the Brazilian financial institution and provide that information automatically to the United States.
What in certain way would create a worldwide compliance.
It has the
regarding
potential.
financial information.
Correct. It has the potential for resulting in worldwide compliance, and it could also result in other countries passing similar laws for similar enforcement and cross-border in all different ways.
And
Yes.
what do you suggest? What are the minimal information that a Brazilian financial institution who shall, as we have seen, comply with FATCA, what they shall know, what they shall do
Right.
in order to comply with it?
Right. Let me give you sort of a very, very general rundown. The first thing that Brazilian financial institutions should do is they should become educated about FATCA. As I said, there are 400 pages of regulations. The financial institutions need to identify responsible groups within their organizations to find out about what needs to be done, what their requirements are, whether they're exempt. They need to perform a legal and operational analysis of their organization, of each entity, each legal entity in their structure, to categorize them as to whether or not they're a financial institution or an exempt financial institution of some kind, or meet some other category. They need to determine, they should determine, try to determine if they can somehow avoid the restrictions of FATCA, if they're exempt from the restrictions, or if there's some way to restructure, to minimize their compliance effort. And this, of course, when I say restructure, to minimize, I'm talking, of course, of totally legal means. They need to determine what systems need to be developed to comply with FATCA. That's a lot.
Yes.
That's a lot of stuff that needs to be done. And
But as I see it, the financial institutions that are already comply with money laundering law have done half of the work. It's going to be easy for companies that are already compliant, right?
They've probably done a lot more than half of the work with respect to their intake procedures for new accounts. With respect to their existing accounts, it depends on the information that they have in those particular accounts as to whether or not that's sufficient. But yes, they've probably generally done a lot of their work, and there's an overlap, but not a perfect overlap between the Know Your Customer money laundering type of compliance and the FATCA kind of compliance. And every country will have a slightly different overlap that needs to be addressed on a local basis.
I thank you very much, both of you. I think it was very profiting, and I wish we have the opportunity to talk again about FATCA.
Thank you very much for having us. It's been a pleasure.
Thank you very much for having us.
You're welcome.